Good morning, property practitioners. Good morning, consultants. Good morning, administrators. Good morning, stakeholders. Can you hear my voice? Can you hear it loud and clear? Can I see thumbs up? Colleagues, can you hear us before we start? Can we see the thumbs up? Okay, advocate, can you hear me? I don't think they can hear me because I see they're raising hands. So I'm not sure if they can hear me before I start. I don't want to disadvantage anyone.
Yeah, we're getting thumbs up now. Yes, I can hear you well. Thank you, Naledi. Yeah, I think we're getting
all right.
thumbs up
I
now,
think they can hear me.
hear us. Yes.
Okay. Good morning, colleagues. Welcome to today's webinar. We're going to look at navigating the processes and practical guidances for consultants and property administrators. So today's webinar is to bring clarity to our processes, and it's designed to provide, guidance and address some of the challenges that you are experiencing, especially when you come to our offices as consultants. And we want to unpack just the key processes, as you go about coming and representing your customers on the other side. We encourage you today to participate, and we trust that the session, will bring value to your day-to-day operations. So before maybe I start with the presentation, on another note, today marks an exciting milestone for the PPRA. So our marketing manager and the chief corporate support officer, together with the CEO, they officially now launching the new website for PPRA. And this platform, it will represent a refreshed digital presence, and it's designed to improve your experience so that when you go into the website, you can access accurate and up-to-date information. So as part of, the launch they're going to do this afternoon up until the evening, I'm sure tomorrow it will be up and running, as they're building it up into the launch. They requested me to play a video for you so that you can see what's coming, into the website, and for you, what is it that you must expect. So I am going to just flag on my side a video so that you can see what I'm talking about. Let me open it. Hold on. Okay, give me a minute. Still loading. Okay, I am going to play the video now. Let me maximize the screen. Okay, so that is the video that the CEO requested we play for you, and our chief corporate officer and the marketing manager. Colleagues, I want to now welcome our speaker that we have today. Remember, we had a webinar with her on Wednesday. Her name is Advocate Deborah Weil. She's the Executive Manager in the Licensing and Exemptions Department here at the PPRA. And, you know, she's been in that department and previously in other departments within PPRA. So she does understand the process. I've muted everyone for now so that we can allow her to give the presentation. I will allow access to the mic and I will take your hands after the presentation. Even if you raise your hand now, we will recognize you after. You can put your questions on the chat box and on the Q&A space. I will respond as and when. But if we receive queries that are not related to registration, we will forward them to the relevant department so they can assist. And the session is being recorded, colleagues. The slides we're going to share after the presentations are done. And if you're having difficulties, try to refresh on your side, log out and log in again. Advocate Weil, are you ready for presentation? You can take us through it. Put it on slide mode.
Okay, yes, thank you, Naledi. Let me just see, is everybody sharing? Is everybody seeing my shared screen?
Yes, they can see.
Okay, perfect. Right, I've put it on slide mode. Okay, everything looking good, Naledi?
Yes, yes.
Okay, perfect. Good morning, everybody, and thank you for joining us. We had a webinar for agents on Wednesday, and this one is for consultants, administrators. Agents are also welcome to join if you're here. We're very happy to have you. But there are a couple of the slides that are directed specifically at administrators, and some of the information which we're sharing is going to be the same as Wednesday, but not all of it. And we can look at some different aspects as we go through. What we'll be doing is going through the slides, and I'll be explaining them in some detail. Those who have questions, please put them in the chat, or otherwise make a note of them and I will answer them afterwards. So we're looking at some of the changes that are coming into the PPRA processes as a result of the Act, and particularly Regulation 4122, also 12 industries, the practical effects on all of us, and basically how far we are with development and what we'll be doing in the near future. So just to explain one of the first issues which are changing and which we need to understand, I'm going to look back for a moment at the historical framework which existed under the EAAB. You'll know that the EAB existed under the Estate Agent Affairs Act and was governed and regulated by that Act. In terms of that Act, each firm had its own Fidelity Fund certificate. Each firm had to have a principal, and it had employees that were registered under that firm, and the employees were either estate agent candidates or estate agent full status agents. And as you know, the EAA Act dealt only with estate agents, and there were certain managing agents that were defined by that Act as being estate agents, although they operated in the managing agent industry. There were some auctioneers that also fell within that Act, and so some of them will also have registered as estate agents. Also, in terms of the old regime, each principal and employee had a Fidelity Fund certificate under the specific firm which he or she was employed under. So the agent had, if he was a principal and he was associated with more than one firm, he had a Fidelity Fund certificate under each of those firms. Each firm, as well as each branch, had to have its own Fidelity Fund certificate. Each director had a Fidelity Fund certificate, including non-executive directors. Every firm and every principal had to have a trust account for which the principal was responsible. And then each firm, principal, employee, and branch paid for a Fidelity Fund certificate to be issued. So that was the framework under the old Act. So we have a look now at what's changed under the new Act, and I can advise that because of the changes that the new Act required in our system, our framework, and our IT development, we had to engage in quite lengthy development of our systems in order to be able to accommodate the new Act. So that's what we've been doing over the last few years, and we are finally getting to a point where some of those developments are beginning to be implemented. And that, of course, is partially the reason for some of the delays that we've experienced over the last few months, because very unfortunately, it's coincided with the renewal season. We have put up numerous notices, explanations, apologies, etc., on our website and in the media, and so you'll be aware of that. Unfortunately, it doesn't remove the frustration, but we're hoping that with all the changes and the developments, we will be able to provide a far better service to the industry. So under the new provisions, each firm still has its own Fidelity Fund certificate, which must be issued in the name of the firm, and it must be valid for 3 years. Each firm still has a principal and its employees, and the names of your principal and your employees depend on which sector you operate in. You'll know that in the estate agent sector, we have an education regulation which applies, which sets out a framework involving a principal, a candidate, and a full status agent. So any person or any employee registered as an estate agent will have a principal, a full status agent, or a candidate designation. If, however, you're in one of the other categories, you will have a director who takes the place of the principal, and your employees who take the place of your candidates and your full status agents. The reason for this is because in terms of the legislation and the education criteria, there is no qualification in any of the other industries except estate agents, which is available for you to complete, which allows you to be designated as a principal or a full status agent. So hence the change in nomenclature. Each principal and employee under the new regime has only one Fidelity Fund certificate. So this is a big change. You'll see that the narrative in blue encompasses the changes which we are looking at as an industry. So each principal and each employee only has one Fidelity Fund certificate. If you're a principal of 5 firms, you only have one Fidelity Fund certificate. Each branch of a firm still has its own FFC. Each director still has an FFC, except that non-executive directors now apply for an exemption, and they then do not have to register with us at all or hold a Fidelity Fund certificate. Same as before, firms can apply for an exemption from a trust account if they do not receive trust money. That's been in for a while, and we've been implementing that. Okay, so your firm can, if it doesn't take any trust money, it can apply to the audit department for that exemption, and there is a prescribed form for that application in Regulation 2. And then another change, only natural persons pay for their Fidelity Fund certificates under the new Act. So firms do not pay a Fidelity Fund certificate fee. There is an admin fee, which is payable for services which are not charged for under the PPA. Now, part of the reason for one of the changes which we are implementing is Regulation 4122. And Regulation 4122 states as follows: where a natural person acts as a property practitioner in different capacities within the same industry, a single Fidelity Fund certificate shall be issued to that natural person in respect of all capacities in which they act as a property practitioner within that industry. So this set the cat among the pigeons. Our system was set up entirely based on the fact that each principal and each firm had to have a Fidelity Fund certificate. The regulations changed that completely to say we will now have only one fidelity fund certificate applicable to a natural person, and that will cover them for all capacities that they operate in within the same industry. They did not say that for purposes of the firms. Your firms still have to have a fidelity fund certificate in the name of each firm. So we had to then do some IT gymnastics in order to find a way of adjusting our system to be able to accomplish this. So let's have a look at the effects of the industry-based or floating FFC, which we are now talking about. So principals, employees, and firm FFCs are no longer interdependent. They are basically independently issued. When a principal renews his own FFC under a specific firm, the firm FFC previously generated and it issued automatically. If he didn't renew under his firm, no firm FFC or agent FFC would issue. Now your firm FFCs are applied for separately, they issue separately, and they may not be in sync with your principal's FFC. And that's in terms of the requirements of the Act and regulations. Your employee FFCs are issued based on your firm and your principal FFC. Your employee FFCs still depend on the compliance of the firm and the principal. Your principal will have one floating FFC for all his firms. Your employees will have one floating FFC for all their employers. Of course, at this stage, we know that candidate and full status agent employees can only operate under one employer in one industry. And a reminder that principals must remember to renew their own FFC when it expires, as well as the firm FFCs when they expire. So bear in mind that they may not coincide. We have an example, Principal Joe. He has 3 firms, Moneybags Realty, whose FFC expired in 2025. He also has a firm called My Property. The FFC expires in 2027 belonging to that firm. And his own FFC, which was issued under My Property, is also valid until 2027. He also has Pay Me Now Estates, which has an FFC which expires in 2025. So Joe does not need a new FFC until 2027, when his longest living FFC expires. He doesn't have to renew in 2025, and he doesn't have to pay anything at that time. In 2025, Moneybags and Pay Me Now need to pay an admin fee and obtain new Fidelity Fund certificates. In 2027, Joe will apply for his new floating FFC. It will at that stage not be issued under any firm, but it will be a floating FFC in the true sense of the word. He must then submit renewal documents for himself and for his current firms. Please be aware of that, ladies and gentlemen. When your principal renews, you also submit documentation in respect of all your firms, as if we are renewing them as well. You don't pay for it, but you do so that we know that you are compliant. And the reason we do it when your principal renews his FFC is because in terms of the Act, a principal who is a natural person must apply by way of documentation and an application form for their FFC. A firm does not have to do so. And on that basis, we therefore don't want to complicate your firm renewal. We want that to just happen seamlessly. On payment of the 640 Rand admin fee, the FFC for the firm will issue, and therefore we adjust our records in relation to the documentation applying to the firm and to the principal at the time that the principal renews his Fidelity Fund certificate. And at the time that Joe renews his Fidelity Fund certificate for himself, he will also renew the My Property Fidelity Fund certificate. Okay, so currently, under your firm FFCs, we can have a look at them quickly. And currently, practitioners under more than one firm have multiple FFCs expiring at different times. While one of those FFCs is valid, there's no need to apply for a renewal. And once all existing principal FFCs have expired, the new FFC will not be associated with any firm. And your firm FFC continues to be issued when it expires. Okay. Just a note, as I've indicated, no application forms required for a firm FFC to be issued. We'd issue them on payment. And there is a request template which you may use if you wish. Regulation 22 does not apply to firms, so please remember that. Or Regulation 4122, sorry, that is a typo. It should read Regulation 4122 doesn't apply to firms, so we don't need any documentation. But if you would like to submit a request for your firm FFC or use the template which we have provided to request your firm FFC, you are welcome to do so. And all that will do is it will give us a heads up that you have paid your 640. We can check that that money has been allocated by finance, and we can ensure that your firm FFC issues. If we don't have any request, we don't know that you've paid 640. We don't know whether it's been allocated and whether it's being issued. So that just gives us an extra safeguard. When the principal renews his floating FFC, he will apply as required by Regulation 4122 and submit compliant documents for himself and all his firms. And he at that stage only pays for his own single Fidelity Fund certificate. When a principal is added to an existing firm or registers a new firm under himself, he does not get a new Fidelity Fund certificate. Only the firm gets an FFC, and payment of the admin fee for the firm FFC and the agent's amendment of records are required. Okay, so you obviously he joins a new firm or he starts a new firm. He's got a floating FFC that is valid. He doesn't need a new one. His FFCs are no longer associated with a firm, and all he then has to get is his firm FFC and pay the amendment admin fees and the registration of his details under a new firm for the FFC for the firm to issue. So in summary, the principal's FFCs no longer have any association with their firm FFCs. Your employees' FFCs no longer have any association with their employee firm's FFCs. What I mean by that is when they get their FFC, it doesn't specify what firm he works for or she works for, and it's not issued under that particular firm. However, please bear in mind that in terms of the legislation, this doesn't mean that if you've got a floating FFC, you can go out there and work for as many different people if and when you want to without registering under that firm at the PPRA. So you can only use that floating FFC for firms that you are registered under with us. Okay, that registration requirement is essential. And because of that, you can then operate under whichever firm you are registered under with us. And if you change that firm, you don't need a new FFC until your FFC expires. Your firm's FFCs must be created using a separate function. Principals will need to request and pay an admin fee for their new firm FFC when it expires. Your firm FFC will still only generate if the principal has a valid current floating FFC. So not an FFC under that firm, but an FFC in general. Principals still pay a 3-year FFC fee to renew their floating FFC. The employees still pay their 3-year FFC fee to renew their floating FFC. A principal who owns a new firm or joins a new firm does not pay to be issued with a new FFC if he has a valid current floating FFC. And for him to be registered under that firm, he will pay a 640 Rand admin fee. For a new firm, the firm will not pay for an FFC as per Regulation 15.1. It will pay an admin fee for its registration. Okay, that's the summary of the change in that regard. Okay, a couple of indicators to administrators and consultants while you are digesting all of this. Just a few provisions of the Act which are essential for you to understand if you're going to assist your clients. As a consultant or an administrator, presumably you are in a position where you are expected to provide information to assist your clients with their registration with the PPRA, with obtaining FFCs, with performing any administrative acts. It's quite important if you're going to assist your clients to do that, that you have an understanding of some of the provisions of the regulations and the Act itself. Now, in terms of, as you are aware, in terms of the property practitioners in South Africa, they all operate in a regulated environment. And to explain to you what a regulated environment means, it means that there is a statute or a law passed by Parliament which applies to operations within that sector. And in terms of that statute, there are certain things that they may do and there's certain things that they may not do. There's also a regulator that is created who has the authority as well as the duty to ensure that that act is complied with. The act or legislation is not something, it's not optional. It's not something you can decide whether you want to apply or whether you don't. It's also not something that we can decide whether we want to apply or whether we don't. We are obliged to do so by law, and property practitioners are obliged to comply by law. I had somebody at the webinar on Wednesday saying, well, why don't you rather give an FFC for 10 years instead of every 3 years? And why don't you do this and that and the other thing? And the simple answer is, if you know anything about the industry that you operate in, which you should do as a property practitioner, you know that those kinds of suggestions can be addressed to Parliament or to the Minister. They cannot be addressed to us because we do not make the law. We don't have the option to change the law to suit ourselves. Otherwise, a lot of things would be very different. But the way that the Act and regulations have been passed into law by the President is exactly how we have to implement them. So we do not have a discretion when it comes to most of the implementation of the Act. And so that's something that administrators and consultants need to be aware of so that they can properly advise clients. What's very important for you to look at is Section 1, which contains the definition of what a property practitioner is. Look under property practitioners. It's a long definition, and I have in multiple previous webinars explained the definition in detail. If there is a request for me to do that again in a webinar, please do send suggestions to Naledi as to what you want me to cover. I'm happy to do that again, but I have done it many times in the past, so I'm not doing it again today. Very happy to do it again in the future if needed. But the definitions are very important so that you can know if you are going to assist your client to register with the PPRA, which industry do you register them in? Section 4 is very important. It deals with exemptions. Do we know what the exemption requirements are? Do we know who can apply for an exemption and for what? Do we know that Regulation 2 gives us the exemption templates, the E1 form? And do we know that that has to be used? Do we know how to fill it in? All those are things that as consultants we would be expected to know so that we can assist our clients. Section 23, auditors and accountants. Now that's very important because Section 23 relates particularly to those who have a turnover of less than 2.5 million and under what circumstances they don't have to have an auditor. They can use an accountant. That's the kind of information which is very valuable to your clients. And if you can provide them with that information, that's I'm sure that would be very helpful to them. Then your Section 26, which deals with compliance notices. You may be submitting a registration application. There may be a compliance notice issue that is outstanding that has not been dealt with. You may not know whether that is the case. You may not know how to find out whether that is the case, and you may not know what to tell your client to do when they have a compliance notice if you don't understand Section 26 and what it relates to. Section 28 covers complaints and disputes. If your client says to you, I'm not getting commission from this agent, do you know what I can do? You can refer them to that section. You can tell them how the PPRA can assist them with commission disputes, etc. Section 47 and 48 should be your Bible. They provide all the information on under what circumstances an FFC must be applied for, when it must be issued, also when it is compulsory to have one, and when you can claim commission and when you can't claim any payment. It also tells you important aspects of how long your FFC application form should take to bear fruit, to be able to be issued with your FFC. Section 50 and 52 talks about amendment, withdrawal, and lapsing of FFCs. Do you know, are you able to tell your client that their FFC has lapsed because they have been deregistered? Are you able to tell them why they have been deregistered? And all those informations are particularly, all that kind of information is particularly important if you're going to give your clients a good service. These are things which we can cover in webinars if you'd like us to do so that we can explain these things to you. Obviously, attorneys are expected to know it. It's part of their livelihood. If you set yourself up as a consultant, you are expected in most instances by your client, depending on your contract with them, to be an expert or to some extent at least, on assisting them to comply with the Act. All right, we can move on to Section 53. Do you know what the requirements are for your client to display their Fidelity Fund certificates? Do you know if a branch needs a Fidelity Fund certificate? Section 54 deals with trust accounts, winding up and deregistration. And this is very important. We have a number of problems where directors and principals appear to think that when they decide that they're taking a sabbatical for a couple of years, or they're going overseas to see their family, or they're retiring, or they're selling their property, their business as a going concern, they simply sign their contracts, they wash their hands off the entity and they disappear. Okay, and that's okay. And you as consultants should be aware, and all property practitioners should be aware, that that is not permitted. A principal and a director of a registered entity who is a property practitioner is never permitted to resign from their entity. The provisions in the Act, and particularly Section 54, relating to deregistration, you'll find it in Section 54(9) to 14, which deals exactly what you are required to do if you as a principal cease operating. It is a winding up process. It involves the closure of the trust account. It involves the payment out of trust monies. It involves the winding up audit submitted by your auditor. It requires a request to us, and you need to bear in mind that until such time as the audit department is satisfied that the firm has been properly wound up and closed, you will not be removed as a principal or director of that firm, and you will remain responsible for all its operations as well as all its trust monies. So on the basis of that, the Act is very clear, and it makes life very difficult for you if you simply try and abandon your firm to somebody else who is not registered with us, because you remain liable, and you then will get nasty letters asking for audit reports, nasty letters or for fines for failing to submit various things. You will attract penalties for failing to advise us that you are no longer operating. And bear in mind that if you are a simple employer, in other words, you don't have a firm, you're not a firm owner, and you're not a director of the firm or a principal, then you simply need to advise us that you wish to be deregistered, you are no longer employed, and you have to do that with us by the 31st of October of every year for the following year. If you don't do that, in terms of the regulations, you are obliged, whether you are operating or not, to obtain a Fidelity Fund certificate, and the regulations are very clear on that. Okay, so don't allow your clients or yourselves as estate agents or property practitioners to fall into that era. Right, accounting records that your client has to keep is set out in section 55. You won't need to know much about that. The auditors or accountants will assist them, but it's good to advise and to remind them. And let me tell you, ladies and gentlemen, it's very, very difficult for an estate agent or for a property practitioner whose auditor submits an audit, and in that audit his finding is a disclaimer, because he says, I had no records to go on, I cannot properly audit this firm, and therefore I have a complete disclaimer of compliance or not, because I don't know. And when that happens, the audit department clicks into gear, because that's when we have trust account monies disappearing, we have all sorts of irregularities happening, and they assume that that is the case because of the fact that you are not doing what the Act requires you to do. So that's very important. You don't want to be in a position like that simply because you haven't kept the required records in terms of the Act and regulations. Section 56 is very important. It explains when you don't have any right to claim commission. Section 58 deals with what associations you can have with other service providers, and you as consultants should know what your association with agents and with other service providers can be, whether you should be registered as property practitioners or not, and under what circumstances. Section 63 deals with undesirable practices. That's very important because there are a number of things which the Act prohibits for estate agents to do. And if you don't know what they are, you cannot advise your clients, and you also cannot yourself comply with the Act. Then I move on to the regulations. Regulation 2 I've mentioned. It's got the exemption form, it's got details. And remember that your Act gives you the law, and your regulations give you how that is imposed, how that is put into practice. And so your regulations give you your forms, your applications, your documents, etc. Regulation 15 is the one that deals with FFC fees. Regulation 20 to 26 deals with FFCs, the format of your FFC, your deadlines, your penalties, your amendments, your updating of details, etc. Do you as consultants know if your client wants to update their details, what they have to do, what they require? Do you know if there are payments associated with that? Do you know if your client comes and says to you, I've got my FFC, but my FFC doesn't say what firm I'm working for. It doesn't tell my client that I'm working for Pam Golding or whichever. Are you able to say, well, there's a good reason for that? And are you able to say what the new format of the FFC is and why that is? All those are important things for you to know. And it simply broadens your knowledge as well as broadens the scope of what services you can provide to your clients. Regulation 31 goes into deregistration details in a little more detail. Regulation 34 is the code of conduct. All property practitioners should be very familiar with the code of conduct. Regulation 38 deals with fines and contraventions. If we tell you that your client has to pay X amount in fines and penalties, are you able to say, hang on a minute, that doesn't sound right. Let me just find out how and why. Or are you only in a position to say to your client, okay, pay that, all right? So, it's important because then you can say to us, just a moment, will you please check and see whether the payment from this date or that date has been allocated? If not, we may find that it hasn't been allocated yet, and that reduces the amount your client must pay. So those are the kind of inquiries that you as a consultant should be able to have, and we should be able to have those conversations. And then Regulation 4122 to 41 is various administrative provisions relating to registrations and fidelity fund certificates. So administrators do have a look at those and see if you can become familiar with them, understand them. If you have questions, you're very welcome to send them to me. And then you can compile for yourselves some notes as to how to address those kinds of problems which come up without waiting for us to come back to you. The other questions which you might like to ask yourselves and you might like to consider and decide what you can do about increasing your knowledge in these respects is, do you know what industries your client needs to register in? Do you know under what circumstances they need to register in more than one industry? Do you know what constitutes a compliant registration application, or a compliant FFC renewal application, or a compliant exemption application? Do you know when these are required? And this brings me to a query that came in recently, and this relates to somebody who wanted to register. A consultant sent in a registration application, and you will find in our application form, it says to you, state the industry in respect of which a Fidelity Fund certificate is being applied for. And in his wisdom, the applicant has said, attorney employees, tick. Auctioneer, tick. Bond and bridging finance originator, tick. Business brokers, tick. Developers, tick. Estate agents, tick. Homeowners associations, tick. Managing agents, tick. Payment processing agents, tick. Property advertising platforms, tick. Property facilitators and intermediaries, tick. Timeshare and fractional ownership, tick. Okay, so he's applying in one application for an FFC under 12 industries. All right, so if a consultant takes the trouble to look at their client's application, which presumably is what they're being paid for, and they see something like that, they should be in a position to say, sorry guys, this is not compliant. What are you operating as? You're an estate agent, that's fine. So you only tick estate agent industry. All right, so it makes things very much faster for your clients if you are able to vet those first. And I know that this is the conversation that we had right in the beginning with Robosa, who's the not the regulator, sorry, the industry body for estate agents, or one of them, one of the main ones. And they came to us right in the beginning and said, okay, please help us to understand what we should check for. What should we know? What can we, where do we look to find A, B, C, and D? And please tell us what's wrong when we submit matters for our members, and how we can ensure that it doesn't go to you and we have to wait another 30 days to find out that actually the guy didn't comply with the act. So yes, very important that we do that. Very important also for you to be aware of is what standards of training apply to register, for example, a developer. Are there any? In fact, at the moment, there aren't. Do you know what standards apply for estate agents? Do you know what standards apply for any other industries? The same applies to auctioneers, mortgage originators. Do you know what a payment processing agent is? Do you know that a payment processing agent has to have a trust environment, which is a special framework required by the audit department in terms of the auditing framework of South Africa? And are you able to assist one of your clients who comes and says to you, I want to register as a payment processing agent, and tell him what you need? What would you say if your client tells you he doesn't have to register as a developer because the definition doesn't include a developer in it? Okay, are you able to say, well, yes, you're right, or no, you're wrong? Or are you able to say, yes, you're right, Section 1 doesn't talk about developers, but Section 1 says that the minister can designate any action or any activity as a property practitioner activity by notice in the Gazette. And do you know that she's done so in Regulation 39, where she included developers who market and sell their own property in the definition of property practitioner? Do you know how to register an auctioneering firm? Do you know who comes in for the principal? Do you know what the status of the agents are? So there are a whole lot of questions. Do you check for accuracy in your applications that come in? Do you use correct PIN numbers so that your client can be helped and there's no delays? Do you understand the difference between an FFC number and a PIN number? And let me explain that to you right now. I have many, many agents and consultants coming in and saying, his FFC number is so-and-so, and then he gives me the PIN number. All right. So just to explain, an FFC number changes. It changes every time you get a new FFC. Your PIN number never changes. Your PIN number is like your tax number. You cannot do anything with the tax department, with SARS, unless you know what your tax number is. You cannot do anything with us unless you know what your PIN number is. Okay? Your FFC number starts with the year in which it was issued, always. And it's a much longer number, and it has various other numbers which have their own meanings for our purposes. So please be aware that there's a difference, and it might seem pedantic to you, but believe me, it's not, simply because when we pay attention to detail, we don't have confusion. We don't have us looking for an FFC number that's actually a PIN number, or we don't. Fortunately, we will know the difference, but we don't have an application where we have to go and try and find this person, because there's 3 different people called Joe So, and we don't know which one it is that you're talking about. Okay. Right, let's move on then to some of our current portal issues. You will be aware we've actually published this on the website on a number of occasions, explaining that our website, our portal, and our SAP system are undergoing development. It's not something we could put off. It's been put off for probably 10 years already. Our system is old. It was brought in 2007. It's had minimal maintenance. It's had minimal updates, and in fact, it's no longer supported by the original holder, the original creator. It's also a system which had to be modified to be able to accommodate what we needed. So we had add-ons created by a developer, and those add-ons have to be modified every time there's a change in the Act. And of course, because of the 2022 Act, it means that we now find ourselves in a position where we have to completely revamp that system. We don't have 80 million rand to pay for a new system, and so we end up having to do some patchwork, some help, some changes, some redevelopment on the system that we have, which is working very well in a lot of respects, but it does take some time. So as far as the current portal issues are concerned, the registration of new agents and the generation of PIN numbers, as you know, is not functioning at the moment. We have asked you to submit your application form to registrations. They will create your PIN number for you, and they will then advise you of that PIN number. They will also consider the documents that you've submitted, and as soon as you then make payment using that PIN number and send us proof of payment, we will then be able to register you. You can, of course, have your client pay using their ID number, and if that happens and you send us proof of payment, because of the fact that you didn't have a PIN number, you used the ID number, it simply delays the process a bit, because we now have to go to finance and say, please look in your suspense account for an amount of X paid in by this person, and it has to be allocated. And those of you who battled with finance issues know that that's not always the fastest process to have to engage in. So in most instances, it's better to simply send us the forms, ask for the PIN number, we'll send it to you, you make the payment, and then send us the form, and the system can automatically allocate that payment. You also know that the FFCs are not displaying correctly. We have issued around 23,000 Fidelity Fund certificates in the last 3 months. A lot of them, for some strange reason, are not showing on the portal, or they're saying issued, but they're not available for download, which of course is absolutely useless to all of you. And with the result, we're having to issue copies of these. We're issuing letters to say, conveyances, we are making copies of all these FFCs that are not available. It has been issued to agent so-and-so, please pay their commission. And we have issued a large number of those as well through the various industry bodies that have asked for it. We also get our IT department to download themselves from our server directly the copies of the Fidelity Fund certificates, and we send them to you when they are requested. We are also in the process, we've been in serious discussions with the IT department to say, please guys, we can't have this happening, especially now it's created havoc for us. Please, you have to repair the portal, even if it's just an interim repair. And so they are doing that. I can mention that there is a new portal that is being developed and is not far from implementation. It is a portal that is only for registrations and licensing, and we'll give you more information on that closer to the time. We will also have noted that sometimes principals try to access their firm, and it says that there's no such firm in existence, or they don't have any other firms or whatever. all of which is completely incorrect. So please do direct inquiries to us. As far as the call center is concerned, I don't work, unfortunately, the call center doesn't work for me, which is probably a good thing for them. It's not a good thing for me. But in any event, if you have a problem with them, and I know many people do, please make sure when you interact with them, you write down dates, times, who you spoke to, exactly what they told you, and exactly why that was incorrect, unacceptable, or whatever, so that we can get onto the call center and get them to step up. All right, so some of the solutions I've already mentioned to you for the problems with the portal. You can request a copy, or you can request a letter of your FFCs or your clients' FFCs, and as soon as we will have them downloaded and sent to you, or we will send you a letter in the interim. Development and repairs are ongoing. Told you about the new portal. The new portal will be able to give you all sorts of updates, all sorts of access to information. The registration activities, information and notices will be put up there. Your employees will be able to be seen. You'll be able to see who's employed under your firm. Their FFCs will be noted there, etc. So we're hoping that it will certainly provide a far better service than we can at the moment. Excuse me. All right, so yes, so we're waiting for that with bated breath. At the moment, please be aware that our new website has been developed and it's being launched, as you've seen. Not sure if it's today or Monday, but very, very shortly. And do go and have a look. You should find that it will be helpful to you as consultants as well. All right, another change which we'll move on to now is the 12 industries, which are now being incorporated into our registration system. You'll be aware that we went from regulating one industry to regulating 12 industries overnight. Our system was only designed to register estate agents and no other industry, and it was also set up so that all the requirements and obligations of the estate agents were placed on the system. They were all part of the laws of the system before a Fidelity Fund certificate could be issued. Now, since those don't apply to the other 10 property practitioner industries, our whole system had to change, which we've now done. We were previously registering the other 10 industries under on a manual system, which we are now going to be migrating into the SAP system, and we are going to start registering new entities under those 10 industries on the SAP system as we move forward. So the FFCs will then be issued via the same system as estate agent FFCs. In all industries will show on the new portal. All registration applications will come via the new portal for all industries. Practitioners will be able to register on the portal for any industry, which they are not able to do at the moment. The new portal will be phased in, phase 1 and 2. We are implementing phase 1 at the moment, and we're hoping, if budget allows, to be able to implement second. Just to reiterate that FFCs are required in each industry if you operate in multiple industries, and your current registrations will go to registrations@theppra.org.za. These are the 12 categories of property practitioners under the PPA: estate agents, auctioneers, bond and bridging finance originators, HOAs who perform property practitioner activities, managing agents, property facilitators and intermediaries. Those include people who operate as spotters, that kind of thing. Business brokers, including sales of franchises and businesses. Developers who market and sell their own developed property. So please be aware that in terms of the regulations, if the developer is simply a builder, he buys a piece of land, he builds a property, and then he sells it through a registered estate agent who does all his marketing and all his selling, etc., for him, he does not have to register. If he develops and markets his own property and sells it either off plan or he sells it by himself once it's built through his own marketing departments, his own marketing regime, he has to register with us as a developer. Timeshare and fractional ownership practitioners now come into the property practitioner regulatory field. Property advertising platforms are also required to register with us. Your payment processing agents are also required to register with us, and attorney employees also. Okay, payment processing agents, for those who don't know, are those who operate trust accounts on behalf of estate agents like PayProp. Okay. Let's look at the registration process and how it's evolving. First of all, let's look at non-estate agent property practitioners. So that's all your other industries. And we look first at your firm registration. Registration is done by the director. He sends his documents to registration at the ppra.org.za. He uses a business property practitioner registration form, which is signed by all the directors, and he submits the required documents which are the firm documents. Okay. And if you look at the firm documents, he has to submit his SIPC or firm documents. He must submit the bank letter confirming his trust account is held in terms of section 54(1) of the Act, or a trust exemption certificate. He must submit an auditor's letter of confirmation for the entities holding a trust account. He submits a company resolution authorizing the registration of the company with the PPRA, a valid BEE certificate, which not necessarily is compliant, but is valid in that it's current and it shows the status, whether that's compliant or not, of the firm. For juristic entities, that applies. So that BE certificate only applies to juristic entities. Your SARS tax clearance certificate for all firms is required, and then your proof of payment of your statutory and administrative fees. Your individuals, as I've mentioned, your directors register themselves individually as well as registering their firm. They do that with the individual application form. They submit their ID document, properly signed and completed individual property practitioner's application form, the E1 form applying for exemption from Regulation 33, which I'll explain in a moment, a proof of payment of your registration and your admin fee. And your employees also, the same form, the E1 form, a letter of employment signed by your director and the employee stating the reference number of the director and the firm, and your proof of payment of your registration fee, and all of that goes to registrations at the ppra.org.za. A brief explanation on Regulation 33 and the reason why non-estate agents have to submit an exemption application under that regulation is as follows. Under Regulation 33, which deals with education requirements, it says that the PPRA must provide education standards of training and requirements, a proper candidacy program, as well as a board exam, which is your professional designation exam, for each and every industry. Now, the Education Department hasn't done that. They're in the process of doing a whole lot of things in that regard, but they haven't got there yet. And as a result, we have a problem with one of the provisions of Regulation 33, which says that we cannot authorize a property practitioner to operate by giving him a Fidelity Fund certificate if he hasn't at least done a candidacy or a practical training component and written a board exam. Now, because we don't have a practical training component for you to do, and we also don't have a board exam for you to write if you're not an estate agent, you cannot comply with that provision. So you need to apply to us for an exemption from that provision. An exemption costs 2,000 Rand. In this instance, we don't charge you, okay, because it's our fault, not your fault. So we don't charge you for this one. You simply submit it and you fill in the form. You don't need to put any supporting material or evidence or anything else like you would with a normal exemption application. And you simply say in it that you are applying to be registered in whatever industry, and we have no standards of training for you to comply with currently. Therefore, can you please be exempted from that Regulation 33 provision? Right, we move on then to estate agent registration. Here you all are aware, principals register their firms and themselves individually. They follow the same process. There are the documents for your principals. They submit the ID documents, the individual property practitioner application form, principal qualifications, if there's some sort of an upgrade that they want to do, or if we don't have record of that, and proof of payment of your registration fee. Your candidates do the same thing, same requirements as under any other firm. All right, as far as education in registrations for estate agents is concerned, I just want to explain something, and this is the process relating to education. Education department is responsible for preparing exams, giving you an exam number, letting you book your exams, marking your exams, issuing you with certificates, etc. That's not something registrations has anything to do with. Education is also responsible to update our system to show that you are now qualified in 1, 2, 3, 4 different aspects and that your training is now complete. Once that is done, you then apply to registrations to be registered under your upgraded status. Okay? And this is because of the changes in the regulations. Before it was done automatically, we could, now we're not allowed to do it anymore. In terms of the regulations, you have to apply. You have to have a letter saying, yes, your employer was employing you as a candidate. He's now happy to employ you as a full status agent. Okay? And on the basis of that, as well as your application form, we can then perform the upgrades. And those who obtain an upgrade, their floating FFC doesn't say what their status is. It remains valid and enforceable, and it can be used in whatever capacity they operate in. So they don't have to pay for a new FFC. They simply pay an admin fee to be upgraded. But please note, we cannot perform an upgrade until the education department has performed the updating of the system to show that we are entitled to issue with an FFC under that particular status. Okay, so that's, I think, dealing with estate agents. Okay, so a couple of general changes. I've talked about the format of FFCs. If your floating FFC has to govern all capacities that you operate in, it cannot say who your firm is, because if you are a principal and you have 5 different firms, it would have to state all 5 firms plus all their addresses, which is why your FFC has your personal details and your personal address. Okay, and that is prescribed by the regulation. It doesn't say what status you are, whether you're a candidate or a full status or a principal, and it doesn't, but it does say what industry you operate in. Okay, and it does say how long it's valid for. It's set out in the form, and this is an official template that's taken out of the regulations. It's one we have to use. I've talked about upgrades. I've talked about the effect of deregistration of firms on FFCs. Now, this is something that we need to remember. We've talked about how we deregister firms. If you, as a principal, have 5 firms, you have a fidelity fund certificate issued under one of the firms, which is valid, let's say, till 2027. Even if you deregister that firm, that FFC, that personal FFC of yours, continues to be valid until 2027 because it operates as a floating FFC. And the fact that it was issued at a time when it was associated with that firm doesn't render it invalid. So it will continue to be valid even if the firm that it was issued under has been deregistered, because it is now your floating FFC as a principal, and it operates as such. So when that FFC expires, you will then renew your floating FFC and it will not be associated with any firm. Just a quick explanation as to why administrative fees are payable. You will be aware that the Estate Agent Affairs Board and now the PPRA receive no money from the fiscus to assist us operating. We are entirely self-funded. We are funded by the industry and whatever other money we can make. We do not get a single cent from the government. We are a state-owned entity. We are not a government entity, and it's up to the state to decide whether they want to assist us in our legal operations or not. We are obliged to be here. We are obliged to do what we do by law, but we don't get any kind of assistance to do so. That was all very well and good when we were operating and regulating one industry. We are now operating and regulating 12 industries. Okay, we have to design education, qualifications, standards of training, board exams. We have to issue registration application forms, consider them, issue them, consider exemptions, which are now allowed, which under the old Act weren't allowed. And all of these services have to be done for free. The only ones that the regulations provide payment for are FFC issuing new FFCs or registering and issuing FFCs. Those are the ones that have specific fees associated with them. All right. So under the old Estate Agent Affairs Act, as well as since the new PPA, a lot of our units have charged admin fees. Okay. Some of them haven't, some of us haven't. And the registrations and licensing department is simply not able to provide the extensive, numerous services that are required without some cost. It costs us a huge amount of money. Our salary bill is by far the highest cost that we have, and that's because we need so many people, partly because there's so much that we have to do under the Act, and partly because we don't have automated systems that allow us to do it, which we're trying to assist to change. Changing IT systems costs a lot of money. Providing the services that we do cost a lot of money. And having looked at what we can do to enhance revenue, we have gone to senior counsel, we've gone to commercial specialists to advise how we can increase our revenue. And the answer from all of them was that we are entitled to charge admin fees, which all state-owned entities charge to some degree or another, whether they need not be authorized because they're not specific fees. We do not charge admin fees that are specified in the Act. So if we have a fee for registrations, we don't charge an admin fee. We assume that that is included in the registrations fee. However, where there's no admin fee, there's no other fee, it's obviously absurd to think that we're supposed to provide these services for nothing. And so that's why admin fees are charged. We have a schedule of fees which is on our website and which you need to have as your second Bible so that you can advise your clients what they should pay. Okay. I talked about the system upgrades, time periods for issuing of Fidelity Fund certificates I'll deal with in a moment, and requirements for Fidelity Fund certificate renewal are some of the changes. We now have to, in terms of the regulations, have proper application forms and documentation for you to renew your FFC. This is something that we put out there on our website as far back as the 1st of July 2025 to advise people, and we've put it up many times since. Please ensure that you supply an application form. We had something like 19,000 applications, none of which had application forms with them. So yeah, that's what happens if we are not able to advise our clients properly. Of course, we can't ensure that they listen to us, but we can at least say that we've done our bit. All right, just before we end, we're going to look at Section 49, which is causing a lot of misinterpretation, a lot of dissatisfaction, and a lot of different views and ideas. I'm giving you the authorized interpretation of Section 4 as provided to us after consulting with the legal experts, as well as discussing and considering the section ourselves. And this is the approach of the PPRA. Those who have a different approach, I'm sure there are many, will obviously view the matter as they wish to do so. This is our approach, and until we have some kind of convincing indication that we are wrong, this is what we are proceeding with. So Section 49(1) says, the authority must, within 30 working days, consider any application submitted to it in terms of this Act, which fully meets the prescribed requirements. And then there's an unless. Unless, on good grounds in writing, we advise you that that period of 30 days for the issuing of an FFC on the basis of an application which fully meets the prescribed requirements is going to be extended for it, and it can be further extended up to another 20 working days. So that will happen where, for example, we have a cyber attack, or we have a flood and everything is damaged, and we can't issue you with the FFC that you are entitled to within those 20 days. 20 days then applies to a situation where we have an FFC being applied for, the application is fully compliant, we are obliged then to issue it within 30 days, and we are unable to do so for whatever reason, and we ask for an extension. We then see a subsection 2, which says the period of 30 working days contemplated in subsection 1 commences afresh if the authority requests the applicant to submit additional information or to correct the application. Right. So if we say to you, after you've submitted your application, sorry, your application is not compliant, please give us the following. And please submit your new application with all of that information. Then when you submit it to us, that 30 days starts. That's fairly simple and straightforward. Then you move on to 49 subsection 3, 49.1 subsection 3, sorry, and it says, if the authority has failed to comply with subsection 1, okay, it doesn't talk about subsection 2, it talks about subsection 1. And what does subsection 1 say? Subsection 1 says, we've got a fully compliant application, we are obliged to issue you with your FFC as a result. It's got to be done within 30 days, but we don't, and we don't ask for an extension. Okay? Or having asked for the extension and having got the extension, we still didn't comply with issuing that FFC. So in those circumstances, subsection 3 applies. If the authority has failed to comply with subsection 1, the application is deemed to have been approved, and the authority must, upon written request by the applicant, within 10 working days, issue the applicant with the relevant certificate. So in the circumstances of subsection 1, where we have been non-compliant, your FFC is deemed to be, your application is deemed to be compliant, and you can demand your FFC within 10 days. Okay, so if we analyze it, which I have done to some extent, but we'll just look at it again briefly. The PPRA must consider an application which fully meets the requirements, so it's fully compliant. If it's fully compliant, we must issue an FFC. We must do it within 30 working days. If we don't consider a fully compliant application within the 30 working days, the fully compliant application is deemed to have been compliant, and we must issue the FFC within 10 days. If it never fully met the requirements, it's clear for us under the section that no deeming provision applies. Section 49.3 specifically refers to 49.1 and not to 49.2. And if it fully meets the requirements, we have 30 working days to issue it. After the 30 days, we have another 10 working days to issue it on your demand. So the drafting of this provision, I don't think is a model of clarity, but I think it's clear enough on the ordinary interpretation of the wording, which is what we are required to use in interpretation of statute law. It seems to be perfectly clear that that is what it is saying. So that is our interpretation of it, and we will ensure that in these circumstances, we will comply with it. Please do not encourage your clients to come and say, you didn't consider my application. I now know that it wasn't compliant, or you say that it wasn't compliant, but you now still have to issue me with my FFC because it's deemed to have been compliant. That is not what the provision says, and that certainly makes no sense in the interpretation of statute law. Okay, for noting, Section 4 exemptions, equivalency exemptions, trust account exemptions, please be aware that costs differ, addresses differ, and criteria differ for all of these kinds of exemptions. The ones that come to us at registrations are Section 4 exemptions at the ppra.org.za. Those are only the exemptions under Section 4, which are those which say that any practitioner can apply for an exemption from any provision of the Act, and they can use Section E1 to do so, and they have to justify why they think they should be entitled to that exemption. Your equivalency exemptions are a different animal completely. They are an exemption which exempts you from complying with the education requirements because you have another qualification which is better than the prescribed one. And that goes to the education department, which is exemptions at the ppra.org.za. And your trust account exemptions are done by way of affidavit as prescribed by the regulations, and they go to audit at the ppra.org.za. So please be aware of that so that you can ensure that you submit your clients' applications to the correct place. Your exemption application forms are prescribed, and your affidavit is also prescribed in Regulation 2. For CPD, please don't send CPD inquiries to us. We don't deal with CPD at all. Please send them to the Executive of Education, which is Zandile Mahlangu at the ppra.org.za. And then please escalate any issues that you have where there is non-compliance with the statutory timeline and with what we are obliged to do by escalating them to me or to the CEO if I am on strike. Okay, so if you don't get any help from me, CEO, but please don't give me a day to do it. All right, as an executive, I have a lot to do. I try every day to get to my emails. Sometimes it takes me a day or two. So please just make sure you give me a couple of days and I will most certainly expedite your matter. But please do not copy anything to me. Okay, it absolutely it makes it very difficult for me to attend to those that are urgent and that need to be attended to. When you've sent an email to Bongan Kosi, he's helping you, he's been there, he's been assigned to help you, and now you send everything and copy it to me because I've already assisted you. So please don't do that. It makes it very difficult. And the other thing, please don't do, and I'm going to move on to the next slide, which you will see is a heartfelt request not to do the following things. Do not send us an inquiry without a PIN number. Do not copy the EM and CEO on ordinary emails. Their emails are for escalation or legal inquiries, not for general registration matters. The new website has a search capability. Please look at it and read the notices that we give you. Please do not send emails to multiple people. All it does is it confuses people because they think, okay, well, somebody else is dealing with this and they don't touch it. It just gives everybody an excuse not to do it. Please don't send emails 15 times a week on the same issue, okay? We absolutely do respond to emails. There may be a few that fall through the cracks. Our systems are not great, and sometimes we have a breakdown in the connectivity. We then sometimes lose emails. So please, you're welcome to follow up with us, but please give us time to do so. And don't think that if you have not complied with something for 3 years and you now are compliant after we've assisted you to become compliant, and you now want something that we're going to be able to provide in 3 days. Okay, it's simply not going to happen. So please be aware of the statutory timelines that we are given. Please be accurate when you send us emails and queries so that we know what you're talking about. Please be specific and clear. Please don't ask for something that's prohibited by the Act. Okay, we're not going to be able to change the Act to suit ourselves or to suit you. So it's just a waste of everyone's time. Please report stupid administrators to the EM, which is me, or to Vukani first before you go to the CEO. Okay, please. Also, remember that the CEO cannot give permission to be non-compliant, even if she wanted to do so. She's not allowed to do that. Please report corruption. There is a corruption whistleblower line on our website, so please use that if you would like to, or you can report it to me. And as I've said, if you have a bad experience with a useless call center operator, please report date, time, and person so that we can assist you. Thank you very much. I hope that that's given you some idea of where we're moving to, and that it's not as clear as mud. I know that there's a lot to get used to, and it's taking us a while to get used to it too. But thank you very much for your attention, and any questions I'm happy to deal with. Over to you, Naledi.
Thank you, Advocate. Thank you so much for the presentation. We have some chats on the platform, but Lerato Molawuzi joined the meeting. She's been trying to respond to those who have FFC queries. So colleagues, if you're putting your comment on the chat or query and you're putting an F number for the firm, also put your email address so she can know where to reply to, because she won't come back to the chat and reply you here with the status of your FFC. So put your F number and an email, then Lerato will pick it up because she has to check the system. She must open your profile and she must check the documents as well. So advocate, and those who are saying, please send the slides, we're going to send them after the webinar. The recorder, we're going to post it on our PPRA TV. And I see We4 says, which email address is to be used for request the letters confirming FFC issued underway, advocate?
Okay. You can, Lerato, please put in the chat FFC renewals at the ppra.org.za, and you can also, as a next to it, you can also send to Katu. Please, if you'll put Katuchelo's email address, because he is issuing those as a matter of urgency, and he will pick them up possibly before somebody picks it up in the FFC renewals mailbox. So either of those can be used.
Okay, this one from Paul, it's a comment: enhance revenue by fines. You brought in 61 million in fines in the period of 23-24 financial year end period. I have a question from Elise. When a full status practitioner have done the NQF5 training, must they be registered as principal before they write their PDE5 exam?
As far as I know, that they do, but I can't answer for education department. You need to check with Zandile, but as far as I know, they do have to be.
Okay. And we have another question here. I'm also going to give access, advocate, to the hands, because we have few hands that are on the platform. I'm just going to allow them to unmute themselves. Okay, while I go through the chat, then we'll recognize everyone. So colleagues, those where Lerato replied, I'm not going to, comment on that one or ask it so that we don't duplicate the efforts. We're only going to deal with questions where they have not been answered. And Annelene says, if two directors does both pay, I think you want to say if two directors pay the renewal fee, but your question is incomplete. Annelene, please raise your hand so that we can reply it properly. Michelle says, does employee refer to the person doing admin in the firm, advocate?
No. Employee refers to a person doing property practitioner activities in a non-estate agent entity. Okay, persons who do non-estate agent activities, in other words, whatever they do doesn't fall within the definition of a property practitioner, whether it's an estate agent or any other kind of practitioner. They don't register with us because they are not property practitioners. Okay, so they are not called employees. Employees are those who are employed by a property practitioner in a non-estate agent industry, and they work for the property practitioner firm, and they perform property practitioner activities for that firm.
Okay, thank you so much, advocate. I'm going to go to the hands and I'll come back to the chat so that we mix it up. Ashla, please unmute yourself and ask advocate a question. Ashla, please unmute. Okay, we're going to go to Marianka. Please unmute yourself and ask the question. Marianka, please unmute. Okay, let's go to Trudy. Trudy, please unmute yourself. Okay, she lowered her hands. Let's go to Rasika. Okay, Marianka managed to unmute. Let's hear your question. Yes, you can ask your question, Marianka. Okay, please check your volume, check your settings. Let's go to Rasika. Rasika. Rasika, please unmute. Okay, Sunel?
Hello.
Yes, we can hear you.
I just quickly wanted to confirm, when you submit a FFC application, is there some way that the PPRA can provide you with a document that to confirm that you actually submitted it? We are struggling with trustees. We're in the managing agent environment, and we're struggling with trustees saying we can't prove that we've submitted the application in the process that we're waiting for it to be issued.
Okay, our system was set up to be able to give you an auto response to say we confirm receipt of your application. I understand that function is not working, which of course makes life very difficult for you as well as for us. So if you want an application, a confirmation that you have applied, you can certainly send the request to us. I think the best thing will be to send it to Lerato at her email address and just ask her to confirm that you have applied and we are in the process of issuing, or that you've applied but we require certain documentation which has not been submitted. So she can give you that kind of confirmation if you need it.
Thank you. That would be great. Thanks.
Thank you. Let's go to Andel. Or Trudy's back. Trudy, please unmute. Okay, she got kicked out again. Let me go to the chat. Advocate, let's see which questions do we have where they are not replied already by Lerato. Let me see. Can I have Lerato's email, colleagues? It's pinned on the chat. You will see her email is pinned on the chat. Just have a look there. Sunil says, okay, we replied to this one. She was asking if we can get confirmation. This is the one that Advocate replied now. Okay, let me see if there's another question. Yolanda says, my application is more than 60 days old without any response to date. Maybe comment on that.
So yes, please send your details and your query to Lerato. She will immediately check and see where it is, what's happened to it, how come it's been overlooked, and we'll come back to you literally within a day or two. She'll come back to you straight away. Lerato, can you just make a note of that? What's the lady's name? Did you say Naledi?
I'll tell you now, Yolanda Fenter. It was posted 12 minutes past 11.
Okay. All right. Lerato, if you'll please just follow up on that as a matter of urgency.
Yes. Yes, I will do that, Advocate. Thank you.
I have Lee who says, are you able to share some consultants' details that can assist? Okay, I lost it because somebody posted. I have to go up to the questions again. Apologies about that. Okay, I'll tackle this one. This one looks like it's a PDE certificate. We will share with you. Lerato, help me to post the education email address so they can follow up on the PDE4 certificate for those who are following up, and also the queries for CPD. The email is cpd@theppra.org.za. They will assist with the CPD questions. Zandile are also forwarded there. Lilani says, my FFC paid in July 2025, still have not received the FFC. I think it speaks to the one similar to Yolandi, where Advocate said Lerato will help. If you can send us all the information so that we can see where it was stuck, what could have been the issue, but they will assist with that.
So it may be that it's been issued, but it's just not available. That's I did talk about the problem on the portal that many agents have had where we've actually issued the FFC, but it's just not there. So we can have it sent to you, or we can send you a letter meanwhile while they try and retrieve it from the server. Either Lerato can send that to Katu for him to assist, or you can send it to Katu. What's her name? Lerato has put that Katu's email address on the chat, and he's kind of the go-to person for FFCs.
Okay. I have a comment or a question from Paul regarding why we're highlighting that staff is a challenge, especially saying they're 50%, because we've been working with the same number of staff for the past 3 years at least.
Sorry, I don't understand the question. What did I say about 50% of staff? I don't remember talking about 50% of staff.
Oh, okay, maybe he misunderstood because he's saying we mentioned that we are under capacity with 50% of staff.
Well, I certainly didn't mention that. I don't know who did.
Okay, let me go to another one. If we have another question here. Because it's mostly the queries where Lerato has taken them down, where we're going to respond. Let me go back to the hands. Yesa Fontaine, please come through and unmute.
Good morning. I'm sorry if this is not the right discussion area, but I have a property practitioner who was a principal of his own firm, did not do what he was supposed to do in winding down his firm and doing all the reports and et cetera, and has been out of South Africa for a while, has come back now and wants to re-enter the estate agency arena, if I can call it that, environment, but as a property practitioner working under a principal in an estate agency firm. How do I go about advising him on, does he need to lock down or I don't know how to wind down what he needs to do in his principal capacity and then do a new application as a property practitioner before he can move on?
Yes, okay. Let me explain the process. If he didn't deregister and wind up his firm will still be active. We will have a whole lot of audit reports outstanding. We will have a whole lot of penalties that has been issued against him. We will have 24,000 Rand fines because he didn't submit audit reports, etc., etc. So all of that has to be resolved. So what you need to do is you need to send an query to Lerato and she'll be able to advise you. But just briefly to tell you what has to happen, he has to come to us with his old F number, or we can find it for him on our system using his ID number, which is now the firm number, and his own PIN number. And we will have to look at that firm and say, all right, you stopped operating in X year. You didn't close your trust account according to us. You didn't close your a firm according to us. You didn't deregister yourself or your agents. We now have to remedy that situation. So what you will ask him to do is we will say, please give us a date on a bank letter signed by your bank, confirming what day what date your trust account was closed. Once we have that, we'll be in a position to say, all right, we need a winding up audit report from the last date that we have an audit report for you up until the date on which you closed that trust account. That winding up report must be submitted to the audit department by your auditor. If there are any that were outstanding at the time that you closed the account, in other words, previous years, you have to submit those as well. Once the audit department is happy, they will then close that trust account. You then have to ask for that firm to be deregistered in writing with a signature, with your signature. And we will then deregister that firm once we've got proof that the trust account was closed and the winding up report and everything was submitted. He then has to apply using a new application, individual application form, to be registered as a full status agent under another firm. And he has to submit your employment letter, he has to submit his ID, he has to submit his application form, and he has to pay for it. We will also ask him at the time, in terms, according to our finance department, you owe us 16,000 Rand in penalties because you didn't comply with what you were supposed to do. If he was not operating during that period, which he obviously wasn't if he's away and outside the country, he can apply for a waiver of those penalties, and he would need to submit to us an application form, which is basically an affidavit saying, this is when I stopped trading, this is when I'm coming back and I want to trade again. During that time I was not trading. Please can you waive the penalties for FFCs that I should have paid because I wasn't trading. And that you can submit. Lerato will give you the details as to where you must submit that to, and he can do that along with his application form. and we can then say to him, right, okay, they've been waived or whatever, and this is how much you have to pay. And we can then register him under his new firm. Please note that whether he can come back as a principal with a principal status, in other words, he retains his principal status, but he goes under to that firm as a non-principal, depends on whether he has all the education requirements which allow him to register as a principal. The other thing is that if he wants to retain his principalship under the regulations,
She
the
just
principal
said not
is
that. She said
somebody.
normal estate agent. Based in.
Sorry, can you just
Apologies.
mute, please?
I'm going to mute.
Okay, so where was I?
If he wants to continue his principal status,
Okay, if he wants to continue his principal status, he has to, in terms of the new regulations, he must have his own firm. So a principal is defined under the regulations as somebody who has a business property practitioner that he operates. So
Okay,
he would
understand.
have to register his own firm in order to retain his principal status. If he doesn't, he will then get the full status agent status if he has got the full status agent qualifications. If he hasn't, he'll have to register again as a candidate. If he has, we'll register him as a full status agent.
Thank you, Advocate. And then just a last question. If he cannot provide the bank letter stating that the trust account was shut down and his auditors cannot provide those reports, is there something that he needs to do instead of that? I'm just covering all my bases so that if he gives me a story about he can't get those documents, is there something I can do?
There actually isn't. There's no other way for us to deregister that firm. But what he can do is, if it's a long time ago, look, the banks have to keep records for 10 years. So if it's less than 10 years, he should be able to get a letter from the bank saying, that was the trust account, it was here, it was held by this person, it was closed on that date. If they can't, and it's no longer on their system, then he just needs a letter from the bank saying, we confirm that this person holds no trust account with us, that it's not on our system anymore, and that it would have been deregistered previously, but that we've got no more record of it. Because on that basis, we will know that it was registered, a long time ago. And then his affidavit, he would have to do an affidavit to tell us, I actually closed down this business and stopped operating on X date. And on that basis, we will then say, your auditor needs to give us an audit report or winding up audit report from this date to this date. If it's so far that there are no records of the actual firm and there was no audit done, or there was nothing, no transactions during that period, then the auditor can also always do what we call a null return in relation to having not operated, to confirm that there's no operations during that time if he's got evidence for that effect. But there has to be a winding up report of some sort, and there's very little else that he can do.
Okay, thank you so much. That helps a lot. Thank you very much.
Thank you. We have Megan who says a developer who develops on different lands and then sells and leases those properties, must they register as developer or an estate agency?
As a developer. He's leasing and selling developed land that he has developed, so he's a developer.
Okay, let's go to the hands, Adrian.
Thank you. Good morning, Deborah, Naledi, and fellow colleagues. Deborah, I wonder if you could go a little bit more into principals who lend themselves out to firms. So non-executive directors set up a real estate agency, they need to have a principal, and then they have a fallout with the principal. As you know, we've had several issues like this, and they suddenly have no access to the trust account, they can't resign, they can't leave, but they can't get out of that situation. And I think these principals who lend themselves out as principals, so they say, I'll be a principal of your firm for X amount of time, but then they have the fallout. I don't think they completely understand the fiduciary duty of being the principal, but now there's nothing they can do. They can't close the firm, they can't have access to the bank account, etc.
Sure. Okay. Thanks, Adrian, for that question. Yes, a very important, everybody. I think this is something that perhaps consultants need to be aware of, and all agents who make themselves available to operate a firm as a principal for somebody. As you will know, in terms of the regulations and the Act, A principal has a huge number of fiduciary duties that he has to comply with. He is personally liable for the trust account. He is personally responsible for any misconduct relating to the operations of his firm by his staff. In terms of the principles of vicarious liability, he can find himself in all sorts of trouble if he is not hands-on in ensuring that the firm that he is a principal of operates correctly. Now, we, as Adrian said, we have many agents coming in and saying, they won't give me my FFC because this one firm that I'm the principal of is not compliant and hasn't submitted its audit reports and hasn't paid for ABC and hasn't done their CPD, etc., etc. And now I can't get an FFC for my own firm or for any other firm that I operate as a principal. And our first response to him is, well, do what's not been done. Why have you not done it? Oh no, the answer is, well, you see, they just asked me to step in as the principal because they weren't qualified, and they said I don't have to do anything. I just have to sign the forms, and I just have to be the principal in name only. I don't have to worry about anything else. They're supposed to have done A, B, C, D, and E. And my response to them is, no, sorry, sir, you're wrong. They weren't supposed to do A, B, C, D, and E. You were supposed to do A, B, C, D, and E. Okay? Your principal is liable to do whatever is required in respect of compliance for that firm. And if he doesn't do so, he becomes a principal at his peril. We say to the principal, look, sir, if you are not in control of the firm and you want to resign from the firm, or they're not listening to you if they're the directors or whatever, you should also be a director in terms of the regulations, where that is a requirement. But if you are not happy where you are, you need to close down the firm, close the trust account, and do everything that's needed. No, but I'm not in control of the trust account. And my response is, excuse me, you are what? No, well, I'm not in control of the trust account. The director holds the trust account. Well, then my answer is, so sorry, I can't help you, because if you as a principal allow somebody else to control the trust account in a firm that you are principal of, then you know what, you really and truly have a problem. You shouldn't be in the industry, because that is your responsibility. Compliance is your responsibility as the principal. You can never abdicate that to somebody else. You can never delegate that to somebody else, because the buck stops with you. So if you are going to be a principal of a firm that is not your firm and you've been asked to assist, please make sure, first of all, that you remain in control of the trust account at all times. Secondly, please make sure that you have the sole authority in terms of the directorships, in terms of the board of a resolution of the board or whatever, to close that trust account with the bank. Okay, and the bank needs to be aware of that so that it will do that. You need to be sure that you have day-to-day hands-on control of that firm to ensure that you are not going to receive a summons because one of the staff have failed to put trust money into the trust account and have made off with it, okay, because that will be set at your door. So please, ladies and gentlemen, be very careful. If you are going to hire yourselves out as principals for whatever fee, cover yourself and make sure that you remain in control of that firm, because if you don't, it will be of no value to come and ask me for help, because I can't help you. You will end up going and spending, excuse me, 200,000 Rand at the High Court to ask the High Court to give you an order which authorizes you to do what you should have been able to do in the first place. Okay? And that's the only way out of that. Does that cover everything, Adrian, or is there anything else?
Thank you, Deborah. That's covered. Thank you.
Thank you. Let's go to Clara. Please unmute.
Hi, good morning, everyone. Thank you so much. I had one question, but it did go to two based on one of the other queries that had been raised. So the first question is with managing agents. So we're a managing agency. We've got our fidelity fund certificate for the managing agent firm and everything. But unfortunately, if you try and search our fidelity fund certificate, because it's now that MAF number, not the previous F number alone. So if you're on the portal, you aren't able to verify that managing agents are actually registered. So if people ask, other than just for your fidelity fund certificate, because obviously we're in a time where documents and things can be fabricated. So if someone is wanting to verify an agency, how can they go about doing that?
Okay, if it's a non-estate agent agency, as I've said, we are in the process of transitioning those over onto the system, but it's going to take a while. And only new firms are being registered on the SAP system in the different entities. So your old firms are still on the manual system for the moment. So what you can do is please send an email to Joseph. Can you put Joseph's WhatsApp address, Lorato, in the chat? Joseph is in charge of manual registrations, and he will have your registration documents. He will have your FFC and everything else, and he will be able to send you an email with his own details as on our PPRA email address, saying that yes, in fact, you are registered, and this is how long your FFC is valid for.
Okay, perfect. Thank you so much. And then with the second question, so previously the company was registered as an estate agent, as all of the various categories were. And at the time, what happened is myself and my fiance, we had purchased the company from the former owners who were also, the one was the principal agent. She remained on, so that while I was busy obtaining my qualifications. Then at the end of 2022, when everything changed that managing agents no longer require a principal, we started with our inquiries to the PPRA to change the company from being an estate agent to a managing agent. At the time, we were told no, what we must do is we must just leave it, register a new firm as the managing agent under the same name, that's fine, and then the old one will dissipate. Basically, obviously what you mentioned with one of the questions that were asked earlier is that the principal has to basically deregister the firm. How do we go about doing that? Because the same trust accounts and everything is still held. The principal is long gone out of the company itself because we're now registered as managing agents. We have our managing agent fidelity fund. So it's basically just a profile with the PPRA that is no longer in existence because they're no longer, we don't deal with the estate agency side. So how do we go about deregistering that firm without the principal being around and without incurring the penalties based on the information we had received at the time?
Is there only one principal of that firm?
There was only one, but as I mentioned, we no longer are an estate agency.
No, cool, I get that. I just want to check if there was anybody else registered as principal at the time or just the one person.
No, it was just one.
Person.
So if you search for that on the portal, you can still see that company. But yeah, how would we go about deregistering that?
Okay, well, unfortunately, that's one of the issues that we have with our call center giving information, which is not correct, and I apologize for that. But what we will need to do, I think the best thing to do is to please send an email to Lorato. She and I will have a look at it and see what is on the system and what isn't. And we will have to speak to audit and see what they want us to do in relation to the trust account, on the basis that your trust account, obviously you don't want to close it, you don't want to wind it up. But what would normally happen is that the trust account would have to be wound up to the point where the estate agency stopped operating and it was transferred to a managing agency. Now, I understand that the estate agent actually never operated. It was a managing agent all along. But there would have to be some sort of closure in relation to the accounts at that point for it to then be registered with us. And I need to clarify with audit exactly what they require. So please, will you send an email to Lorato so we can resolve that problem and we can get all those penalties reversed by finance, because it's obviously incorrectly charged. If that's what was done. And so, yes, please do that. Lorato, if you'll just make a note of the lady's name and details so we can recognize that when it comes, and then we will be in touch with you as to how we can wind up that other firm.
Thank you very much. I really appreciate that. Then I've looked through the chats. I don't see Lorata's email address. It might be a little bit further up. If you wouldn't mind just putting it on, or otherwise pinning it to the top, that would be very helpful. Thank you.
I'll give it to you just orally as well, in case anyone's not seeing it on the chat, but it's Lerato, Lerato .Molotsi, MOLAUTSI at theppra.org.za.
Perfect. Thank you so much.
I hope I got that right, Lerato.
It's correct, Advocate.
Thanks. Okay, thank you.
Okay, thanks. Let's go to the other hand. Cynthia, please unmute yourself.
Good morning, ladies. I have two questions for you, please. What is the turnaround time expected from the registrations email? Because I emailed it about 2 weeks ago and I've not ever had a reply.
Is that to register a new person, or what were you wanting to do?
A company and persons. I
Okay.
actually wanted to understand this whole process and how it worked first, because it's very difficult to figure out.
Okay, well, did you see my explanation? Did you hear my explanation in the slide? On the
Yes,
registration process?
yes, so I'm going to go ahead and do that, but I'm just wondering, once I submit, how much time must I allow before I follow up or query? What is your turnaround time?
Okay, the statutory turnaround time for the issuing of registration and fidelity fund certificates is 30 working days.
Okay, so it
That's
applies
how
to
long
both.
Yes, it applies to both.
Okay.
But do, if you're not sure and you didn't get a response to your query, please send another one to Lerato. She will be able to, just with anything you're not sure about, she'll be
Okay.
able to give you the information, and then we're more likely for you to be able to give us a fully compliant application, and then we won't need to come back to you.
Okay, thank you.
Right.
And then my second question is, we are operating as a developer and the managing agent, and we want to
Right.
do fractional ownership. Do we have to have 3 separate entities for each of those, or can you do all of that in one entity and just register once?
No, you can do it in the same entity. You can do it in one entity, but you have to register 3 times because you have to have an FFC for each. So your firm, your one firm will have 3 FFCs, one as a developer, one as a managing agent, and one as a fractional ownership practitioner.
Okay, all right. Thank you very much.
Advocate Alessandra, on the chart, what are the requirements for an HOA, Homeowner Association, to comply with the PPRA, and must they have FFC?
Okay. Homeowner associations are required to register with us and have an FFC if they perform property practitioner activities. Okay. So your homeowner associations generally do not perform property practitioner activities, or traditionally they didn't. Majority of or a large number of owners associations have jumped on the bandwagon and said, and somebody corporates as well, I might add, and said, okay, well, we're going to have our own little in-house estate agency, and if you want to sell your property in our estate, then you have to first give it to us to sell, or if you give it to somebody else, you have to give us a percentage of the money that you got when you sold your property. And then we will also market your property on our website or whatever, so that it helps you to get buyers. Okay, first of all, the requirement for you to use their in-house estate agency is unlawful. It's an unfair practice in terms of the regulations, and they can't do that. But what they can do is they can have their own in-house property practitioner or estate agent firm, where they say, give it to us and we will do it, and we'll charge you a bit less, and we'll advertise and blah, blah. Or if you use another firm, you sell your property, you have to give us 1% of the sale price or whatever it is. So if they're doing that, then they are performing property practitioner activities. And then they have to register with us, the same as any other property practitioner within that particular industry, using the same process that I explained in the slides.
Okay, thank you. Andrea says, hi, I'm currently employed by an attorney who also has an estate agent company. I'm also a practicing attorney and employed as her estate agent. Do I register as an estate agent or attorney employee?
Okay, I'm a little bit confused because first of all, if he has an estate agent company, the estate agent company has to be registered with us and has to have its own FFC apart from the Law Society's FFC. So I'm assuming that he has registered himself as an estate agent because he's operating outside his firm. Now, if he's operating two separate entities and the one is registered with us, obviously his attorney firm doesn't have to be registered with us. So if you are an attorney and you're working for the estate agent firm and you are performing property practitioner activities, you have to register under the estate agency firm as an estate agent, irrespective of your law, your legal status and the fact that you're an attorney, because you're not operating as an attorney, you're operating as an estate agent. If you're employed by the estate agency simply as their legal counsel, in other words, you're not performing property practitioner activities at all, you're simply drawing up contracts for them, you are vetting the stuff that they do and making sure that it's legal and compliant, etc. Then you are not operating as a property practitioner or estate agent under that entity, and you don't need to register with us, but you will just continue in your employment as a legal consultant under that firm. If you are employed by the law firm, the actual law firm, you cannot be employed as an estate agent. You can be employed as an attorney employee who is performing property practitioner activities within the actual law firm. Okay, so in that instance, you are an attorney and you don't need to register with us. So those are the three scenarios. I don't know if that answers the question.
Thank you, Advocate. Narisa, please unmute and ask your question.
Good morning, everyone. I have 3 questions, please. I just want clarity on when you email registrations to generate the PIN. I've got conflicting information. What documents do we actually need, please? And how long does it take for that PIN to be given to us?
Okay, you would normally send in your normal application, all your application documents with your application form. You would just not send in your proof of payment. They will then give you, as soon as they've done that, they've checked your validation of your documents, etc. They will then give you the PIN and you can pay. So it would be, they would have to do it within the 30-day period so that you can pay and get your FFC within the 30-day period. So yeah, so that's basically the turnaround time there. If you're concerned, you can send, you can escalate it to Dongenkosi or to Lerato. Lerato perhaps is the best person from here, and she can just assign it to somebody to follow up and make sure that it's being dealt with.
Okay, thank you. And then you mentioned the website that's coming up by Monday, but the second phase, I think that's where the portals will have access to that. When is that expected to be up and running?
Okay, the first phase of the portal we're expecting to be up within a month to 6 weeks. The second phase we're not sure. We've got it has been drafted. We know what we need to do. We also want to use the same developer, obviously. And we've got a quote for it. We just need to check that we've got budget for it. So that might only come in the next 3-4 months. But the first phase, which is the most important part for registrations and licensing practitioners and applications, as well as for FFCs, should be in a month to 6 weeks maximum.
Okay, thank you. And then the last thing is regarding section 49, where we can go and demand only if the application is compliant. The PPRA form is completed correctly, the employment letter is there, the ID is there, as well as the proof of payment. This has been since the middle of last year, because before July, because I started in this position in July. So we're still waiting on this. I've emailed several times. I've been to the offices. I still haven't received this. So how do I demand? When you say demand, what do you mean? And what should I be doing to demand this FFC? Because it is compliant.
Okay, well, please send it to me. You can, send it to me so that I can have a look at it and see and check that it is compliant. If it is, we'll issue your FFC within 48 hours.
All right.
But if it's not, and there's some other, maybe there's a block somewhere, I don't know if it's a principal or not. If the principal hasn't had an FFC, then obviously
No, the
we can't
principal
issue it.
does. No, sorry,
Principal does.
everything's in order with the company.
That's fine. Then if it's compliant, we'll issue it within 48 hours. So please do send it to me. What's your name again?
My name is Narissa. But I am in communication with Lerato at the moment, so
okay.
we'll
All
just
right,
add
well,
that.
that's fine. We'll follow up on that. Okay.
Thank you
good.
so much.
Thank you.
Okay, thank you. Advocate, I have Cheryl who says, can estate agents operate as powered by? I need clarification to be answered, please. Does this company and estate agents operating in this manner as if they are registered estate agencies with the PPRA, but they are saying they are compliant and are valid because they are powered by? Advocate?
Okay. Thank you for the question. I think it's something that we will be issuing some media statements about shortly. We have been involved in a lot of these kinds of issues. There is no such thing as powered by. It doesn't exist. It's not recognized by the Act or the regulations, and it is not compliant. Somebody who operates their own firm, who does so, and with themselves as a state agent candidate or a state agent, full status agent, and is not a principal and is not registered as such, cannot operate their own firm, whether they're powered by anybody or not. Okay, so what the position is the following: we know that EXP Realty had a business model in terms of which they would get people on board who would advertise themselves as an estate agent powered by EXP Realty. We spoke to EXP. EXP was very, very clear with us that they are sorry, they're taking away that powered by. None of their agents will be able to use powered by anymore. What they can do and what they have to do is either the agent has to be employed by them as a full status agent or as a candidate agent and has to operate under them, under their principal. All right, that firm has to be registered with us as a principal, as an estate agent, and it has to have the principal registered, either the EXP's principal, or it doesn't register with us and it actually operates under EXP, and EXP's principal is responsible for that firm. Okay, so nobody is allowed to go out there and say, all right, I am Debbie Vile Properties, but I'm registered under EXP as a full status agent, but I'm advertising myself as Debbie Vile Properties powered by EXP. That is unlawful. All right, I am not allowed to operate under a name that is not registered with the board and that doesn't have a principal that is qualified to operate that firm. All right, so anybody who uses powered by, it's of absolutely no value to anybody. They have to show you the Fidelity Fund certificate in the name of the firm that they are employed under, and they have to show you the principal's FFC as it's registered with us, and they have to show their own FFC indicating that they can operate as an estate agent. But all the operations, their marketing, everything else has to be in the name of the employer, which is the firm that they used to say powered by. All their marketing has to be under that particular firm.
Okay, thank you, Advocate. I lowered Rasika's hand by mistake. I'm going to allow Rasika to please unmute and ask your question. Rasika? Rasika? Okay, you're not winning. Let's go to Fiona. Please unmute, Fiona. Fiona? Fiona, please unmute. Okay. Tinas, please unmute.
Hi, good afternoon.
Good afternoon.
Yes, we can hear you.
Advocate Vile, I just want to also start by saying thanks to Lerato. She's been an incredible help for me because I've taken over admin responsibilities at our firms. So she's been very helpful. I've got one question really. I'm busy with the change over from a CC to a PTY limited. So we've done all of the registration documents. I'm busy with that. I just want to know which fees I must pay in terms of, because I've got 3 directors. One is the principal, and then obviously the new firm under the PTY limited. So I'm just not sure of which fees would apply to me to pay.
Okay, so if you've got a valid Fidelity Fund certificate under the CC, your Fidelity Fund certificate remains valid in respect of the company, so you don't need a new one.
Okay.
What will have to happen is your new firm, will have to have its own FFC. So that will be a 640. That will be the 640.
Admin fee.
What's it? Admin fee. Yes. Lorata, just come in. Is there anything else? The name reservation has to be done. Is that right?
Yes, that's correct, Advocate. The
So
name
that's 300
reservation
rand. You'll be asked to just advise us, and Lorata can assist you with that, because I know that the name reservation on the portal is not working.
Yeah, no,
so
that's a problem. We did it previously, my predecessor, but it seems to have fallen away. I don't think they actually fully complied with what you needed. So it's the 640 for the firm,
and then
name
300
reservation is
for
300.
the name reservation, yes, and we can just
And
check
do I
that the
need to
name
do
is
a
fine.
change of anything for the directors, because we've got a few companies, but obviously in different. But we've got 2 companies in the real estate industry. That's where they're holding their FFCs. The one in the CC, 2 in the CC, and one's already with the other one. But so they are compliant with that. Do I need to pay like an admin fee for them to be associated with the new PTY limited?
For them to be transferred, I know we do the transfer from the CC, the people from the CC, we simply transfer them to the new PTY. Does the admin fee apply for that, Dorotho?
Yes, the admin fee applies, Advocate.
Okay, yeah. All right, so all of your agents and your
rand
directors.
per, sorry about that, 640 rand per director. So it will be 3 directors.
Yes, because we need to make the amendments.
And any agents that need to have their employment amended.
Correct. That I know. I was just concerned about, I wasn't 100% sure. So it's 640 for the firm, 640 each for the directors, and then 300 for the name reservation.
Correct. That's right. That's correct.
100%. Thank you so very much. And thanks, Lorata, again for all your help always.
You're welcome. Thank you.
Thank you.
Okay, colleagues, thank you so much for joining the webinar today. We managed to get to our time and exceeded with 7 minutes, but I'm glad everyone, you managed to ask all your questions. For Fiona Rasika, we couldn't hear you. Please send us an email with your questions so that we can assist you after the webinar. And please look out on our social media. We're going to post another link, another flyer today for next week's webinar on contracts. And all the queries and the email address for Lerato is pinned. Ingrid, we were about to close. Advocate, do you want to take that one?
Which one is that, sorry? The Ingrid,
there's a hand from Ingrid. It came now. Should I take it?
Yes, sure, if you want to.
Ingrid?
Thank you so much for the opportunity. I actually pasted my question in the chat. I just wanted to know, does the social housing sector also fall under the PPRA? In other words, do the SHIs or ODAs managing their own staff also need to register as property practitioners?
It depends on their model, their business model, and it depends on whether what they do is actually property practitioner work. The other thing that we would need to look at is who the registered owners of the properties are, and how that occurs. There's a whole lot of questions which we need to look at in order to be able to answer that. In principle, a lot of social housing doesn't fit under us for a number of reasons. And if you look at the definition, you'll see that there are some exemptions, there's some exceptions. There are some instances where certain activities may be performed but are not property practitioner activities for purposes of the Act. So if you'd like me to give you some information, please email me and I'll be and tell me the details of what their business models are like. All the details that you have, and then I'll try and get back to you with some assistance.
Thank you so much. I appreciate that. Thank you.
Thank you, Ingrid. Okay, colleagues, we're going to post the slides on the PPRA TV, and I'll also email everyone who registered. We're going to have a stakeholder engagement in Northwest on the 25th of March, but we will share the information and the webinar as well. We're going to have it around March regarding and the contract. It's on the 25th of February. We'll share the link today. And I see the questions on the website. I did inquire with the marketing manager, and they're saying they're facing the portal in, but they're going to communicate. Please look out for their notice. For those who are around Sandton or Johannesburg, you can come to our offices, because I've seen that when you walk in, you get to resolve your queries quickly, because we have another office in Cape Town. For those who are in Cape Town, you can access the office there. Colleagues, thank you so much for joining. Advocate Vile, thank you for the presentation. We will definitely do another one.
Can I just mention something before we close? Thank you very much to East London, Polokwane, all of those who joined us. We're very, very pleased that you were able to do so. Some of you will be aware that we have a list. I have a list of consultants and administrators who I send notices to, I send copies of changes, and I send invitations for these webinars. So if you want to be on that mailing list, please do email me or Monica, our registration secretary, monica.lee, Lee, at theppra.org.za, so that we can put you onto that mailing list, especially if you're somewhere outside Joburg, so that you have some contact with us. Thank you, Naledi. Thanks very much, everybody, and thank you, Naledi, for organizing it.
Thank you, Advocate. Everyone, please drive safe, enjoy your lunch, enjoy your weekend. We will talk again next week and on email. Goodbye. Thank you, Larato. Bye-bye.
Thank you. Thanks, everyone. Bye-bye.
Bye-bye.